plaintiffs John A. Coyle individually, derivatively on behalf of East Bay Inc. and derivatively on behalf of ABE Inc.
Okay, Mr. Black, if you could state your name for the record.
Albert C. Black III, Trey Black.
So you guys have filed this motion and withdrawn and filed it. And so are we actually going forward on the receivership motion today?
Your Honor, we are. This is Michael Donahue. We are, but we're asking for the appointment of Dennis Rusian as the receiver.
I don't know that person. I'm not appointing him a receiver. So if you want to, I have Trey Black here. Mr. Black, if you want to introduce yourself.
Hello, my name is Trey Black. I've met with both parties, councils before. I think I was the person that was appointed last or considered last on this. So I understand the issue of the case. I will be very candid. Dennis Rusian is a fine lawyer and receiver. But at the same time, I do have experience in state court, being appointed now over 50 times throughout the state of Texas. And I believe I'm qualified in order to handle this receivership.
I guess the only way I would appoint this, what's his name? I don't even know who this is. Dennis Rusian. How do you spell his name?
It's Roossin.
Unless Mr. Cram wants to consent to Mr. Rusian, then we're going to go forward with Mr. Black if we appoint a receiver.
Well, obviously, Your Honor, I'm opposing the appointment of a receiver, period. Not so much for the Dallas property, but the plaintiffs have expanded the motion to include properties not only outside of Dallas County, but in other states. And even the order contains properties not even contained in the, or referenced in the motion.
Referenced in the motion?
The motion for appointment of a receiver.
Your Honor, if I could as well, I have worked with Dennis Rusian. I have retained him as counsel, and I'd be if appointed today, well, then I certainly would retain Dennis Rusian, as receiver's counsel, if that would help. I have a strong relationship with Dennis.
Mr. Donahue.
Well, Your Honor, still haven't heard Mr. Cram voice his whether or not he would oppose Mr. Rusian as receiver himself.
Well, I mean, well, yes, any receiver.
In fact, the receiver's appointed.
Yes, I mean, I'm opposing any receiver, Your Honor, especially outside. If for the Dallas property, I have no problem with Mr. Rusian. I have a problem with any receiver outside of Dallas County properties.
Okay, there's no consent. All right, so I'm going to appoint a receiver. So just the issue is the only properties that would be affected in this receivership or that would be collectible. And Mr. Black, I know that you've talked to the parties, but I want to make sure that we're all on the same page. Is there was a judgment that was entered in this case that covered how many properties, Mr. Donahue? Did the judgment?
Well, the judgment addressed one specific property, the Forest Lane property in Dallas. But there are other properties owned by East Bay and ABE Inc.
And those were also part of the judgment that right?
No, Your Honor, they weren't part of the judgment. The other properties weren't addressed in the judgment, just the ownership of the two corporations, ABE Inc.
Right, but okay, so I'm sorry, I'm not being very clear here, I guess. So those corporations own certain properties at the time of the judgment.
That's correct.
And so those properties are impacted by the judgment.
They are impacted by the judgment.
So only those properties that are impacted by the judgment, so that were part of ownership of those two companies, those are the only ones that should be. Any properties owned by those two entities at the time of the judgment are subject to the receiver. Does that make sense, Mr. Black?
Yes, Your Honor.
And I do think in this case, it's going to be important, given the history, to probably have counsel, because you're going to be dealing with possibly trying to, because there's going to be real property in other states. You might have to file enforcement actions in other states. And I mean, this could get to be kind of involved.
Yeah.
All right. Anything else, guys?
What? And well, Your Honor, I guess we're going to talk about the order submitted by the plaintiff go far beyond what you've delineated. Just
Copy the order. Wow, this is so long. Okay.
It's just got attachment to it, Your Honor.
All right. Where do you have a specific issue?
Uh,
Let me borrow a pen. I didn't bring a pen down. Yeah.
So- this order extends.
Just give me line and page.
Page 4, line 3. It
Page
extends.
4. Line 3.
It extends the power of the receiver to all those properties described on Exhibit 1. Your Honor, all the properties that are attached to this order as an exhibit are properties that were transferred out of the two companies. They are not owned by the two companies at this time. The one Dallas County property, as part of your judgment, you voided the transfer deeds out of AVE Inc. and
Were they owned? Were these properties owned by the entities at the time of the judgment?
No, sir.
Your Honor, if I may, and it's set forth in our amended motion. The properties, every one of them were owned by AVE and East Bay at one time, not before the judgment. That's correct. But those properties, just as John Kenneth Coyle, the father, had done before with the Forest Lane property, were then transferred out from AVE and East Bay to another corporation that he controlled, the father, Ken Inc. That's what occurred.
Okay.
And so there's a dispute as to the ownership of all of those properties.
And that is not before the court.
He did the same thing with respect to the father to these properties. He transferred all of those properties out of either AVE or East Bay without the authority of my client, the sole shareholder of both companies. That's what occurred. And that's why we're asking for a receivership to be appointed at this point in time to maintain those properties through a neutral receiver wherever they are in Texas. And there's some, as Mr. Cram noted, they're out of state. There's some in Colorado, there's some in Illinois, and elsewhere. And those are part of Exhibit 1 to the order appointing the receiver, includes those properties. The properties each one.
And the problem I have, Your Honor, nowhere in the motion before the court that we're on today, is there anything putting those properties back into AVE Inc. or East Bay Inc., voiding the deeds out of AVE Inc. or East Bay Inc. There's nothing before the court right now that would put those properties back into titled in the name of either AVE Inc. or East Bay Inc.
Well, that's because those properties were transferred without authority, improperly, illegitimately by the father from East Bay and AVE to Ken Inc., to his company, just as happened with the Forest Lane property. The same situation occurred.
But why wasn't that litigated in the trial then?
That wasn't part of this lawsuit. Was just a declaratory judgment as to this particular property. That's true.
Okay.
But we're asking for a receivership as to all the properties that are disputed ownership with respect to AVE and East Bay.
I'm trying to think what's the correct mechanism. So I agree as the Dallas, we voided it. Has there been a determination that these transfers were fraudulent? I mean, we did for the Dallas property, we did determine that it was fraudulent. And these other properties, there has been no determination it was a fraudulent. And so the way you've written this receivership, I guess the way I envision it is as to the one property, you would have a receivership over that, you take over it. But for the two entities, the receiver would have to
Litigate.
litigate the issue of whether or not to take over, or whether or not these other properties were fraudulently transferred. That would be up to the receiver to decide. But weren't there properties that were owned by these two entities at the time of judgment?
At the time of the judgment, they had previously been transferred. In fact, the lawsuit was pending when this lawsuit was pending at the time they transferred.
Why didn't we
Transferred all
decide
those
those
properties.
issues in the previous?
Why didn't we? It,
Yeah.
it wasn't decided. It was not addressed as far as the other properties are concerned.
Why? I guess why not?
It wasn't part of this lawsuit.
Okay. So what was decided in this lawsuit is those two entities, so there's going to need to be a determination made as to each of those entities, each of those properties, I guess, whether or not there was a fraudulent transfer that occurred, right?
A fraudulent transfer or those deeds themselves, just as we're doing in this court,
Mhm.
we've also filed another action to void these later filed deeds. To have those voided
In
by
what court?
It's before your honor. It's back to be heard on Monday.
Okay, all right.
And we're
In
looking
a
at doing this.
separate lawsuit.
It's a separate lawsuit, but we're looking at doing the same thing with respect to the other properties. Because that's what occurred throughout. Is these improper unauthorized deeds were filed in record with the county clerk and the real property records of each county. And we're looking to have a judicial determination that those deeds were unauthorized and void and ordered to that effect.
And as I stated in my response, Your Honor, venue for those would properly be in the county where they are. And I listed the case law to back that up, that when you're removing some kind of cloud to title, it has to be brought in the county where the property is located.
You may be right about that. Is that true on venue?
Well, as far as venue of a property concerning,
But
Real property.
have you even asserted that in the other case? So have you filed a motion to transfer venue?
The one in the other case is a Dallas County property. It deals with this Dallas County property that we're talking about.
But in the other lawsuit, I thought you said that the other properties were addressed in the.
in the other lawsuit, Your Honor, it does still concern the forest land property. In other words, after our declaratory judgment declares that East Bay and ABE are the owners.
Right.
All right. During the pendency of the lawsuit, come to find out, 2 more deeds were filed
As to
John
that
Dennis.
property.
as to this particular property. forest
Okay,
land.
what about for the other properties?
Same thing occurred with respect to the other properties in other
But the hearing on Monday doesn't address these
It
other.
does not, just the forest land property.
Okay, and then what? Is that part of that other lawsuit, or is there another? How are we resolving this issue? I
We're
guess?
doing that to have clear title so that the property can.
To the Dallas property.
Yes, sir.
But what about for the other properties? What are you
Well,
doing?
we're looking at probably filing similar actions.
In
every
those
one of those
counties.
Yes.
Mr. Black, this could get to be pretty extensive. How
Yeah.
many properties are we talking about? There's a lot.
How many properties are there?
20?
So,
Well,
so Judge, a couple things. One is that traditionally what I've done in larger receiverships that included several properties within one, I do partner with Briggs Freeman Commercial. So if those properties ever need to be liquidated, within sold for best value, within we have a team, Briggs Freeman Commercial, that would be able to handle that. Also, one of the things that I would do is bring in Dennis Rusine to be my counsel in this, receivers counsel, if I'm appointed, in order to help with some of the more sophisticated matters that could be in other states as well. And so, so I think that we would have a solid team in order to address the concerns of this court.
So I just want to make it clear. So this order is not appropriate in my opinion, because what it basically skips an important step, so we need to get a new order in. So what has been established in this case that's before us today, the Coyle versus East Bay case, is the ownership of East Bay and AVE. Those are owned by the plaintiff. So The question is as to each of these 20 properties, when those deeds were transferred away from those two entities, was that a fraudulent transfer, or should the deeds be voided, or whatever, however you want it, however those are dealt with. And so that issue, unfortunately, I may not have jurisdiction over that. So conceivably, you might have to file up to 20 different lawsuits. I'd encourage you, if there's like, it looks like there's quite a few properties in Houston, is that right?
That's correct.
That, yeah, there's a lot of these are in Houston, that you try to consolidate. I mean, it's obviously, I'm not trying to influence anything, but I would caution you that I want this to be done as expeditiously and efficiently as possible. So filing 10 different lawsuits in Harris County when you can do it in one, the court may look at that as being not an appropriate use of resources. So try to be as efficient as possible.
Yes, sir.
So get me a new order on this. You can start after Monday, hopefully, dealing with this Dallas property and doing whatever steps need to be taken with that. But for these other properties, you're going to need to take over ownership of the company and then start litigating these issues if there can't be an agreement reached. Mr. Cram, I will tell you that I don't see how this is at all in your client's best interest to do this unless you honestly believe that these were properly transferred. But I don't see how that's.
I guess the biggest thing I have, Your Honor, the case is on appeal to the Court of Appeals. We have finished the briefing. I expect they'll set our oral argument, I guess, this summer sometime. I don't know how fast they set oral argument after they get the briefs in Dallas. So we're kind of anxious to see, on the chance that we do have the judgment reversed, if all these properties are gone and all the money's been paid to the plaintiff, it doesn't do us much good. And I guess that raises the question, Your Honor, as for the Dallas property specifically, if when that is sold, what's to be done with the proceeds? I would like to have it deposited in the registry of the court.
Yeah, I think that makes sense.
And that's fine with us too.
Okay. Anything else, guys?
No,
So
sir, Your Honor.
get me a new judgment, share it with Mr. Black, share it with Mr. Cram, and the details of what I just said. Make sure that the order says that this was heard on, like it is here, on 25th of March, and make sure it details the issues. The receiver's bond, what is the proposal on that?
Well, I think they testified that it was $7 million in properties, or maybe that was the value of the companies, I guess. I think on their exhibit to their order, they did not list the tax value. I guess, Your Honor, I would request $1 million bond.
Okay. I've never done a $1 million bond, but all right, go ahead.
Yeah, Your Honor, right now, the only property that I believe the receiver is just outright, as I understand from Your Honor, going to be able to take over is the Forest Lane property. And I know there was a sales contract for what, 1.8? 1.8 million. And I would suggest 2% of that.
Which would be what, 36,000?
That's my suggestion.
Mr. Black, what's your position on this?
I have sold property more than a couple of $1 million with no more than $1,000 surety bond, right? And have operated businesses that are worth more than 7 million for a lot less. very candidly, and again, I've been appointed over 50 times throughout the state of Texas on a number of issues that included real estate and businesses, and I've never had to never have those orders had $36,000 bonds. I think that $1,000 bond is enough in order to cover this matter for the type of receivership this is.
For now, why don't we do 1,000? If it turns out that we need to litigate the issue, if he needs to litigate the issue of all these other properties, then we may need to increase that. But
That'd be fine.
let you take it over and then figure out. And you may look at this, and your attorney may look at this and decide you may not want to pursue these other lawsuits. I don't know. I don't know the facts of all these other transfers, and so some of them may be legitimate, some of them may not. I just don't know. So you guys make your independent judgment on that. All right. Anything else, guys?
No, for your honor.
So I guess for clarity purposes, Your Honor, I'm just trying to understand your ruling on with respect to the order on the receivership. Is the receivership appointed as to all the properties that we have?
No, the receivership is pointed to the two companies
Okay.
and to that one property. So the Dallas property and to the two companies, and then he needs to have the power to, I don't know if you,
Okay.
and then he has, I think you want to make clear that he has the ability to file suit on behalf of these entities and it may be in here like subject, he can operate and conduct the business. I think you should go into a little more detail about he has the right to file suit on behalf of the companies to determine ownership of these other entities, the contested entities, and maybe what needs to happen, because I don't really want the receiver to go beyond what's in Exhibit 1, which are these 20 properties. If let's say that receiver finds out about another property, I would probably want him to come to. So you might want to list. He has the right to file suit to determine
As to specific property.
as to whatever's in Exhibit 1. For any other properties that he may decide that he would need to get permission to court first. Does that make sense, Mr. Black? So there's about 20 entities entered into 20 entities here. You need to just, out of those 20 entities, if you want to go beyond these 20 entities, and let's say you just determine there's another store that should be included, you would need to get permission of the court to be able to file that lawsuit.
Yes, sir.
So
Okay.
I don't think that will happen, but
yeah,
I've seen
Okay.
stranger things.
I can draft that up, Your Honor, and circulate.
All right. Go ahead.
One question, because of the expensive nature of this particular receivership, and it looks like this will be, there will be a lot of legal components to this, and inexpensive from the legal standpoint of it, possibly. The proceeds of the sale will go to the registry of the court, but then as the legal fees are paid, well, then that would be paid from the registry of the court, or will I be able to retain at least a portion of the proceeds in the receivership estate in order to pay for legal fees, just so that we don't have to waste the court's time, party's time of coming back in order to address that component in order to pay legal fees, any other kind of expenses of the receivership within the first 30 to 90 days.
What's your position on that?
Well, my position on it is that the order should just address what he's able to do with the Forest Lane property, and they separate.
But how does it get paid?
My position, I need to speak with my client, but I don't necessarily have an issue with paying attorney's fees, and the receiver incurs from any proceeds from the sale of the forest.
Okay.
Okay, but you guys, I anticipate that you guys talk about the exact wording and how that's going to work, and try to come up with the agreed language as to how that exact dynamics.
You want that addressed in this order?
Mr. Black, don't we usually have that addressed in the order?
Yes, we would like to. Yeah, so we don't have to come back with an amendment. There may be, there obviously will have to be a couple of different amendments, but let's go ahead and try to get this as tight as possible in this initial order. Would be greatly appreciated.
And you want the order to also state that Mr. Dennis Racine is retained as counsel for the receiver?
Yes.
Oh, you're Mr. Oh, I'm sorry. I didn't know that. I apologize. I didn't know you were. Never, I don't think I've ever met you before. Maybe I have, so.
I believe that there was a trial many years ago.
Okay.
In your court, that I participated in.
Sorry. No offense. I just don't know you and I don't, I'm sure you're a great, you're a great receiver. I just have never used you before.
I do know Mr. Black, and I have a high regard for him.
Good.
So, and I didn't realize the court had a preference.
Yeah.
I know, I suspect I would have waived off the time.
Oh, well,
But I'm happy to assist. And
but you're a licensed lawyer, right? Licensed attorney.
And so I can help them with that. And I have experience in receivership matters. The way you're going about it in terms of the payment makes sense. And I tend to agree that the receiver is a natural custodian of the proceeds of any sale, and that we can set up procedures for the application necessary, otherwise administrative procedures to make sure.
If you guys agree, I don't have any problems. If there's a big issue about it, just bring it back to me.
Very good.
All right, guys.
Thank
Thank
you,
you
Honor.
so much. Can you, all right, you guys are all excused. I'm not sure what time our next hearing is. Can you ask Rhonda, or do you have the sheet there? What time is the next hearing?
At
11.
11.
All right. Tony and the interns, you guys will sign back on at 11 and everyone else is excused. Okay.